Law and Corporate Governance, Chapter 4. The law across the globe depends on each country. Each country has its law originated from one of the most popular laws, such as the English common law, the French civil law, the German civil law, and the Scandinavian civil law. As you notice, we have two main laws, which is the common law and the civil law. Let's talk about it. Two of the most influential legal systems are civil law and common law. Civil law is a codified system, which means that it's a written down system. The law is written down and gathered for everybody to abide by. When it comes to judicial precedents, it does not treat all cases equally, meaning a case or that happened a year ago might not be treated the same today depending on the circumstances. Civil law is less protective of investors, and some of the French and German civil law originate from Roman law origins, whereas Scandinavian countries which have the same civil law, they were developed by their own civil law traditions. Common law, on the other hand, is a non-codified system, which means that it's not written down. It is, it could be said that it exists on the mind. When it comes to judicial precedents, common law treats all the cases similar, which means that a case happened 5 years ago, 2 years ago, last month, and today should be treated the same or equally. Common law is more protective of its investors, and it originates from discrete ruling of independent judges. The difference of protection between common law and civil law. For example, English common law protects its economic activities. What that means is that it's solely focused on where money goes. And why is that? Because it has a weak parliamentary power and laws were codified by the state or government. Without codified rules, investors have law protections. So there's no set of laws saying let's protect our investors. On the other hand, civil law for the French and German civil law, they protect more the property rights. And why is that? Because the control of the courts was passed from the crown to the parliamentary and the property owners. So pretty much the owners want to protect their property, right? So they should start creating laws to protect their own property. Country and the origin of law. The English common law, which is mainly practiced by Australia, Canada, Hong Kong, India, Ireland, Israel, the United Kingdom, and the United States. The French civil law, which is practiced or has influenced by Argentina, Belgium, Brazil, Colombia, Ecuador, France, Mexico, Spain. West German civil law is mainly found in Australia, Germany, Japan, South Korea, Switzerland, and Taiwan. Scandinavian civil law, which is practiced by Denmark, Finland, Norway, and Sweden. As you can see, we can see a pattern here that the majority of the countries that practice their corresponding law at one point were ruled by these countries, which is the English, the French, the German, or Scandinavian. What does law have to do with a corporation or a company? The benefits of allowing a corporation vary. In this case, the law gives the rights to shareholders to elect the board of directors, receive dividends on pro rata basis, participate in shareholders meeting, and sue a company for expropriation. The legal protection depends on the country and the historical origins of its law. For example, investors may not hold the same rights in the United Kingdom and Italy. Both of the two countries have different laws. Consequences of law. Major economic consequences. Some of the consequences are pattern of corporate ownership and valuation, development of capital markets, and economic growth. If you were a shareholder in a civil law or a country that practices or has its origins in civil law, you would have a weak shareholder protection, but you will be able to have a higher percentage ownership of the company. Having a higher percentage ownership would actually create conflicts of interest between large controlling shareholders and small outside shareholders. On the other hand, if you were a shareholder in a country that has common law, you will have strong shareholder protections. The company ownership is less concentrated, which means that it's a low percentage ownership, and its concentrated ownership can be seen as a rational response to weak investors' protection. Let's take a look at this table on Chapter 4, Exhibit 4.3, which is titled "Does Law Matter? Italy versus the United Kingdom." So here we can see Italy and the United Kingdom being compared side to side. So the origins of Italy is French civil law, whereas the Kingdom is the English common law. The protection rights for the shareholders in Italy is very low, whereas the United Kingdom is very high. In both countries, people have ownership of the company, but in Italy, it's a much higher percentage than the United Kingdom. And the stock market cap GDP in Italy is 38%, whereas the United Kingdom is 208%. And the number listed of stocks in Italy is 339, whereas the United Kingdom is 2038. To summarize, today we talked about the origins of law, which can be English common law, French civil law, German civil law, Scandinavian civil law. We also talked about the difference between civil law and common law, which depend on the country that practices it. We also talked about the difference of protection, which some of them would be civil law protects the economic activities, whereas common law protects the property rights. We also talked about the shareholder benefits, which can include the right to elect the board of directors and the right to sue a company for expropriation. And lastly, we talked about the consequences of law and why they happen, which in the civil law, shareholders have low protection, whereas common law, shareholders have a high protection. Thank you very much for watching, and I look forward to watching your videos and presentations.